This is a regular scheduled meeting of the Pinehurst Board of Adjustment. Some disappointment, perhaps, for some of you. There were 4 items on the agenda. There are now only 2. The first published item that was withdrawn in the second publication had to do with an issue of a tree, and that has been completely withdrawn. The second issue had to do with an A-frame sign in the village, and that will be heard at another date. Some housekeeping things before we get started. Setting a quorum, and we have 5 people, which will accomplish that purpose, but I need a couple of motions to get us the rest of the way. Motion first, please, and this is not mandated, but it is a tradition in the Board of Adjustment that the ETJ member becomes a permanent member of Board of Adjustment. If I could have a motion, please, to nominate Julia to be a permanent member of the Board of Adjustment. Thank you. Second from Leo. Any discussion? Let's vote. All in favor?
Aye.
Aye. And Julia abstained. Welcome, Julia. We now have 4 permanent members sitting at the tables, and we need a 5th for the purpose of this meeting. And of course, the motion would be, if someone would make it, please, that Kevin would serve as the voting member today.
So moved.
A second, please.
Second.
Thank you. Motion from Leo, second from Julia. All in favor?
Aye.
Aye. Okay, we're ready to do some business. This procedure, of course, is being videotaped, and using the microphones is pretty important, as I'm constantly reminded. First item on the agenda before we get to a hearing is to approve the minutes of the last meeting. They've been distributed. Any comments? If not, I'll take a motion to approve those.
I would move to approve the minutes of the Board of Adjustment meeting of July 6th, 2017.
Second, please.
I'll second that.
Thank you, Miles. We'll just vote. All in favor?
Aye.
That's unanimous. Thank you. And now, please, a motion to move into the first public hearing, which had been known as public hearing number 2.
So moved.
Before we start?
Put a microphone on.
Before we start this, I asked for some additional information.
Not yet. We have to open the public hearing. Will you second the opening of the public hearing?
Yes, I'll second that. Sorry.
Okay, thank you. All in favor?
Aye.
Aye.
Okay, we're in the public hearing, and I'll read that into the record, and then, Kevin, you can offer forth what you may want to add to it. The purpose of this public hearing is to receive testimony for a variance request from Section 9.13 fences, walls, and columns for property at 260 Lake Dornoch Drive. The property is located within the R30 single-family zoning district, further identified by Moore County PID 0001998. Specifically, the applicant and owner, Peter Mattei, pronounced right? Mattei, I'm sorry. Peter Mattei is requesting a variance from lakefront rear fence setback requirement of 30 feet to a setback of 0 feet in order to construct a fence in the rear yard. Before we begin the presentations, we do need to swear in. Attorneys are optional because they operate under the court system, but anyone that's going to give testimony should be sworn in, and Gwendy will do that. Mr. Mattei, that would be you and anyone else that may speak for you.
Please raise your right hand. Place your left hand on the Bible. Swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Great. If you want to have a seat at the table with the mic, we can get started.
Yes, sir. So I'm requesting a variance for my property. to change the setback from 30 feet to 0 feet. I'm making this request because I think that changing the setback will create a fence that's more aesthetically pleasing to the community based on the dimensions of the property and the location of some shrubs and ground cover.
Okay. Kevin Drum indicated that he had a piece of information that he requested of the village, and he has a copy for all of us. I think it has to do with property lines, but would you describe it and give one to Mr. Matei?
Sure. The picture, all it is the picture didn't show the setback lines, and we estimated where the property line and the setback line was. And I'm going to give you a copy. I just, this additional information I requested. Okay. And sir, all it is enhancing your information. There's nothing.
Thank you.
Thank you. Thank you.
If I could elaborate on this,
Please.
Board. Kevin did come with me. If you notice in the packet that you have, the survey provided by the applicant didn't show the 30-foot setback. So the rendering you have before you is it's to scale. It's pretty much accurate, but it's a representation of where the 30-foot setback line would be from the property line, as well as the approximate distance of also that 30-foot setback line from the lake shore. So the plus or minus 60 foot represents the distance from the lake shore to the 30-foot setback line, and the 30-foot setback line represents the distance from the property line.
That was the question I asked, and I had to provide it to everyone since I asked it.
Questions for Mr. Matei?
Well, let's me start off. What is the objection to the 30-foot setback, and why can't that be done?
So the objection to the 30-foot setback is that it places the fence in an area of the yard that is more visible to the rest of the community, and that detracts from the kind of natural beauty of the property. And putting it actually further towards the lake provides more coverage from the natural vegetation so that the fence is actually less noticeable. So someone standing, at the golf course or at the bridge would probably notice the fence a lot more if it was placed at the 30-foot setback, and it would not look as nice. And I believe the spirit and intent of the ordinance is to maintain the beauty of Pinehurst golf courses and lakes. And I think in this instance, it may act contrary to that, depending on the board's assessment.
I see that there is a neighbor to the south, a single-family home constructed in 1981. Do we have any statement provided by that neighbor?
We do not. It would have to be live testimony.
I see.
And is anyone here to speak from CCNC?
Yes, we do have someone that represents.
Oh,
the
why don't
club.
we? There was a reason for you to touch the Bible. There was a reason for you to touch the Bible.
Right.
Could we have your name, please, again?
Yeah, my name's Perry Youngblood. I'm the chair of the Architecture Review Committee at CCNC.
Barry, speak into the mic, please. Thank you.
I'm the chair of the Architecture Review Committee at CCNC. So we received a request from Dr. Matei for the installation of this fence around his backyard at 260 Lake Dornick Drive. We carefully reviewed the request and found that it met the requirements of our guidelines, so we approved the request, and we then sent a letter to the village from the Architecture Review Committee and the club general manager in support of Dr. Matai's request. I want to emphasize that we carefully review any requests for fences, and we do not approve them if we feel the fence will detract either from one of our lakes or golf course. We determined that Dr. Matai's proposed fence will not have either of these issues relative to a lake or a golf course. While Dr. Matai's backyard is on the water, it's not a typical lakefront property where a fence would detract from a view across a lake. The water in this case is more of a creek that feeds into Lake Watson than it is you would consider a part of the lake. Also, there's no residential properties across the water from Dr. Matai who would have their views affected. And there's not an impact on the view from a golf course. So as we view it, Dr. Matai wants to enclose his backyard so his small children can make use of the yard. And as Dr. Matai said, we feel that if it's not approved, if the variance is not approved, that the result will be less attractive than if he can follow the natural contours of his backyard with the fence. So, representing Dr. Matai's neighbors, we urge that you grant the variance.
Thank you. You may want to remain there in case someone has questions of you. Folks, if and when we do vote on this today, it'll require 4 of 5 to approve. And the question we will be asking ourselves now is, does it meet the 4 standards which have been presented in the write-up? I don't know if any of you want to explore those. That's the issue of hardship from strict application of the ordinance, hardship from conditions that are peculiar to the property, and so on.
Yeah, I'd like to just go through all 4 of them.
Great.
The first one stipulates that unnecessary hardship would result from the strict application of the ordinance. And it shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. I don't believe this application can meet that standard. The installation of the fence, no matter where or without the variance, is not an unnecessary hardship, in my opinion. So, in my opinion, that standard cannot be met or has not been met. I believe the fence can be constructed at the required setback without creating a hardship. The second standard indicates that the hardship results from conditions that are peculiar to the property, such as location, size, or topography. And hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. There are some peculiar conditions on the property, but not to the extent that this standard can be met. A fence located at the appropriate setback of 30 feet, again, in my opinion, would not be a hardship that would be peculiar to this property. The third standard says the hardship shall not result from actions taken by the applicant or the property owner. Well, I don't, that's a fact. The hardship, if there is any hardship, whether it's 30 feet or 0 feet, the fence will still serve the purpose without creating a hardship. It might provide a little less area for a backyard, but I believe the 30-foot setback still provides enough room for the purpose of a play area. And the fourth standard requires that the requested variance be consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice is achieved. Whether the fence is created at the 30-foot setback or there is no setback or there is no fence, the property has existed without a fence for many years, predating the PDO, and I don't believe that the absence of the fence creates a safety hazard.
I would make a couple of comments, and then let's invite the others on the board to speak. In the third one, which I refer to as C in the write-up, to me it's very clear that buying the property, knowing that it might need a variance to accomplish something, is acceptable in this appeal. And with regard to the word hardship, that was tested by me in my first meeting almost 6 years ago, where I asked someone what it meant, and of course it says it's in the eyes of the beholder. There is nothing in North Carolina law that specifically defines the word hardship. The last item, I also would take the opposite view of you, that with particularly regard to public safety and substantial justice. I don't quite know what that means, but I would find that the test for the last one had been met, as well as the third one, and I would likely argue the definition of hardship for the first two, but I think we should hear from the other people on the board.
I have a question, sir. Mr. Youngblood, the decision from the Architectural Review Committee, was it unanimous? Yes, it was. Have there been any objections from any of the residents?
Not aware of any.
Mr. Mattei, sir, have you heard any objections to what you'd like to have accomplished?
Miles, I think that would end up being, that's not evidence.
Okay.
Sorry, but it'd be good to have that information, but it's not evidence that we can consider unless it's here and someone's testifying to it.
Okay. Fair enough.
As the backup guy, I want to ask a point of order, and I don't know if it's proper, so you're going to tell me in a minute. Can I find out the exact intent from staff on the setback requirements on golf courses and lakes? Is that a question worth asking? I'd like to know the intent of that.
The basis of my understanding is that really the golf courses and lakes become kind of a secondary public realm, just as there's additional regulations for fences in front yards, given that there's courses of play, there's view sheds, there's those sorts of things. It's really to protect that secondary public realm of the lake and the golf course. In some instances, it could be, particularly golf courses, the course of play It could be views, aesthetics, numerous other things come into play in order to deal with that public realm or the protection thereof.
Could be egress to the shoreline, maybe? Like a boat or something, I don't know.
Well, in many instances, you have sewer lines and those sorts of things that would run along the lake shore, but I don't think that's the intent from the zoning perspective. It's only a secondary
Okay.
provision.
Okay. Just wanted to ask that.
Any other questions you want to raise, or?
Do you know, Mr. Youngblood, the property opposite, on the opposite shore, is that, I see, at least in our picture, it looks like it's set off into lots. Is that ever slated for development? Do you have any idea?
I stood in the backyard and looked across the water and didn't see any homes. Is that correct, Peter? And so I think it's, there must be woodlands between his lot and any lots that would be across the water. There's some land that's a little to the left of there across the water, but that's really adjacent to a golf course. So there are no homes there that would have a view that would be affected.
And it sounds like from the testimony you gave before, your feeling was that when we're thinking about view planes, the view plane from the lake isn't one that really comes into play with this particular property because of where it's situated on a creek, as you indicated?
Correct. It's really not what you would typically be concerned about as a lakefront location. At CCNC, if there's a lakefront lot, we strongly discourage or prohibit fences because we don't want them to affect the view across the lake, but that just doesn't come into play here.
And from your testimony, it sounded like the feeling from the Architectural Review Board at CCNC was that the view from Lake Dornoch Drive was enhanced by having the fence at the 0 setback rather than the 30.
Yes, that's correct, because it would be more near the plant life shrubbery at the back of the lot, rather than if the setback is applied, it would pretty much cut his backyard in half and would be more visible.
Okay, thank you.
More visible to what?
More visible probably from the street, which was what she was asking about.
More visible from the street?
It would be closer to the street and probably more visible from the street. If it's
There's a,
more integrated with the plant life that's closer to the lake.
I don't believe it would even be visible from the street with all the existing vegetation plus the house that's located on the property. There are fences on the property or on the adjacent property. Is that not correct, Dr. Matei? There's a fence on the property to the south of you? But that's not on your property. The lot directly adjacent to you on the south side of your property.
South side is in this map.
270 Lake Dornoch is the property he's asking about.
There is I don't know that I would call it a fence, it's more like
This is the south.
one of those green wire structures that are more temporary. I mean, is that what he's talking?
Yeah, I'm really not aware of what's next door.
Okay. I was on the property yesterday, and I saw a fence, essentially black chicken wire, I would call it.
Yeah, that I think that was not that's not something that was constructed on my property. I
Right,
believe
that's existed for some time.
I think they may have put that there to prevent like leaves from moving. I'm not sure how that got there, but I can't really speak to it.
Now, on the north side of your property, the side of the property that's closest to Lake Dornoch,
Uh-huh.
are you aware of a fence there?
On my property?
Yes, sir.
There is I think maybe a fence that's kind of up along where the creek is, where somebody could fall in there.
Does that go all the way to the lake?
No, it does not.
Okay.
It's just, it kind of follows where that stream feeds in.
It's
and
just a post and beam fence with the
Yeah.
chicken wire on it.
And no, that's, I think it's like a split rail fence.
Split rail,
Yeah,
I call it a post and
Okay.
beam.
then we agree.
That does have some screening or fence material
Yeah,
on it.
that fence, I'm not sure if it was constructed at the same time of the property or if that was there prior to the property being there to prevent people from falling where that dam is.
Okay.
So I can't speak to it other than that.
Thank you.
Any other board member have additional questions?
No, I just wanted to note, I was there this morning, and beautiful property. I asked to go in the backyard, and I guess your wife allowed me to go back there, and I noticed that the fence was there, and it went all the way to the lake, all the way into the lake. It's like I don't know what it is, chain link maybe, I don't know, but it goes all the way in, and it's on the neighbor's property, so it goes all the way down. I just thought it was interesting. And as far as just to get to where, where I am, I agree with 2, 3, and 4 are met. I'm just talking to myself about 1 and trying to define, the unnecessary hardship and how it is in the eye of the beholder. And
Okay. Folks, we can leave the hearing open in case you want to continue discussing and think you might have more questions, or we can close the hearing. If we close the hearing, doubtful that we would reopen it, and we can consider a decision right now, or we can hear the next case, if you will, and get back to this one. Does anyone have any reason why we should keep this open for additional questions?
Fred, you may want to make sure there's no one in the audience that may have anything else to offer.
That's a good question. Anyone else like to speak on this matter?
I'd like to just follow up with the question that Mr. Drum addressed about what is the purpose of the setback provisions. And that's the way we were thinking about this from the standpoint of the Architecture Review Committee. If this fence would have affected the view from a golf course or a view across a lake, we would have not allowed it. We would have not approved it. In this case, we didn't think either of those was a problem, and so we did approve it.
Well, there are several houses directly across this, what do you want to call it? The lake. In view of this rear lot, there are no fences on those lots across the lake. And consequently, I guess, from looking at this property from the other side of the lake, this would be the only fence that would be seen.
I guess you've been there since I was, but my recollection from visiting the property was that standing in the backyard here, there were not houses in view across the water. It was just an area next to the golf course. So we didn't see that properties across the lake would be affected by this.
Anyone else like to speak that's sitting here? Board, are you ready to close this hearing then?
I guess so.
Okay, I'll take a motion to close the hearing and re-enter our regular meeting, please.
So move.
Leo, and second
Second.
from Miles, all in favor?
Aye.
Aye.
Unanimous. We now have a choice. Would you like to discuss this further? Would you like to vote? Or would you like to move on to the next issue and get back to this?
I'd like to have some more discussion with the board, amongst the board, and deal with the question and vote.
Okay, why don't you lead the discussion if you'd like to have that?
Well, as I specified with regard to the standards, I don't think any of them apply to this application. And so if there was a motion made, in the affirmative, I would be opposed.
Okay.
I feel it meets 2, 3, and 4, and I want to discuss with my team members number 1, and because I think it could be argued there is an unnecessary hardship on everything from the HOA to the homeowner.
Well, I read number 1 as sort of being a threshold issue. If you don't find 1, you don't reach 2, 3, and 4. You
Right,
know, the
right.
unnecessary
So I just
hardship
wanted-
must exist, so that's the kernel.
It's about 1.
Yeah.
It's about 1, and the definition of unnecessary hardship, and that's where I'm at, and I think it could be argued, they're arguing they have an unnecessary hardship. And I think that I'm just trying to define it, and I was hoping my team members could help me.
For me, the thing that makes the difference is Mr. Youngblood's testimony. Because what is a hardship here is, in a sense, property value and hardship to the community. And an argument could be made that if the fence is going to be put at that 30-foot setback, it's going to harm the community through the site plane from Lake Dornock Road, or Lake Dornock Drive. But it seems that there is no harm to the community as far as the lake view goes. And an argument could be made that putting that fence at the 30-foot setback in some ways could diminish, perhaps insignificantly, but could diminish the property value. So in my mind, I think you could reach unnecessary hardship. Once again, how much of a hardship is it? You know, that's really...
I'm not sure that we're dealing with degrees on something that's not defined by law.
Right.
I would say there's a third thing, too, that it's going to be seen, whether it's done on the 30-foot or not on the 30-foot. So it's a matter of, which provides less of a, I mean, I guess what I'm saying, there can be a fence there at the 30-foot line that can be seen. So I think there can be a fence there. It's a matter of where it's going to be. And I don't know why I felt that was worth saying, but I did.
And I feel like we have significant testimony from Mr. Youngblood as a representative of the Architectural Review Committee that they've outlined that there are no objections. And exactly what we're talking about here was that at the 30-foot, it could potentially be a hardship. Whereas opposed to if it was a little bit further back, it sounds like it might be less sightly or less unsightly, correct? Yeah.
Hearing's
Sorry.
closed.
Yeah, got it.
Good point.
I have to say, my additional documentation makes me, do some, floodplain, the water could come up, so you don't know, but there's significant room in the property line to the lake. And that was why I did this follow-up document. There's significant room. In some areas, it's up to 30 feet from the property line to the lake. And that is weighing on me, too. And,
If there are no other comments or discussion between us as a board, I would suggest this. Someone make a motion to approve, someone put up a second, then we can have further discussion or vote. We don't need the language that we have in planning and zoning where we say it's consistent. It's simply a motion to approve as requested or deny.
And I make a motion to approve as requested.
Is there a second to that? Second from Kevin Drum, thank you. Any further discussion? Otherwise, we'll go to a roll call vote then. Leo, you're on the record. You want to say it again?
I would vote against approval.
Okay. Julia?
I'll vote for approval.
Miles?
For approval.
Kevin?
For approval.
And synonyms, I guess. I'm for. So it's approved 4-1. Thank you very much. Thank you, Doctor. Okay. We have one other case to deal with today. It's referred to as public hearing number 3. I think that's going to be you, Mr. Buck Adams. And do we need to swear in anyone else that hasn't been sworn in this matter? Okay. Thank you. If you want to make yourself comfortable. I'll poll the board. I didn't do it on the last one, and that's my error. Does anyone have any financial interest in the outcome of this, or have they had any ex parte communications regarding it?
No.
No.
Okay, thank you. I will read
We
this.
did close public hearing number 2, right?
Yes. We did. Yes. You're testing me after the last meeting. Yeah, challenge accepted. That being the case, could I have a motion to open the second public hearing, please? And then I'll read the case into the record.
So moved.
Second.
Miles, motion, second Leo, all in favor?
Aye.
Aye.
We are now in public hearing number 2, and I will read it into the record. The purpose of this public hearing is to receive testimony for a variance request from Section 9.2A, Table of Dimensional Requirements for property at 1144 Chicken Plant Road. This property is located within the R210 Single Family Zoning District, further identified by Moore County PID number 000-29912. Specifically, the applicant and owner, Carolyn McAllister, is requesting a variance from R210 dimensional requirements and asking that the R30 single-family dimensional requirements apply. And I'll turn it over to you.
Good afternoon. My name is Buck Adams, and I'm a lawyer here in Pinehurst, and I'm accompanied by my client, Carolyn McAllister. You have seen our request. This is an unusual piece of property in that it's roughly an acre size, and it has been that size, I might add, by deeds dated all the way back to 1981, which predate, of course, the ordinance. It's unusual, again, in that it's surrounded by properties that are more appropriately zoned R210. In this case, 1 acre zoning, as you might have seen from the survey, makes the property basically unusable for residential purposes. If you apply those, the applicable R210 setbacks to it, you end up with just a very, very narrow rectangular area within which construction can take place, far too small for anything even remotely resembling a residential dwelling. We believe that because of the size of this property, that R30 zoning is much more appropriate for it. And I would also add that there are some properties in the vicinity of it. There's one across the street, actually 2 across the street, one directly across, and one farther down Chicken Plant Road, back toward Linden Road, that are residential, that are roughly the size of this property, and they are again being used at this time as residential properties. So the lot, as we would develop it under R10, or my client would be consistent with those other 2 uses. Again, this just seems to me to be an outlier, a property that really, I think, in my view, unfortunately, was caught up in R210 zoning, which really is just not applicable to it.
Would the board like to ask any questions?
Yes. Does anyone know what the net acreage is when the road area is deducted?
Give me a moment. Let me see if I have that information with me. Minus the road, the county calculates it as .639 acres.
I'm sorry?
The county, minus the road, the county calculates it in its tax billing, for tax billing purposes, at .639 acres.
Thank you. And you indicated that a residence could not be built on this property
Under R2.
under the R210 regulation?
Yes, sir. There is a, if you look at the survey, you'll see the surveyor has depicted, like I say, a small, sort of a rectangular area within which the construction could take place.
That calculates roughly to about 2,700 square feet.
The
dimensions are roughly I'm averaging the lines parallel to the road and taking the depth as scaled from the drawing of approximately 28 feet. That results in the 2,720 square foot approximate area for a building, honoring the setbacks of the 210 zone.
Is that, are you looking at which area are you looking, are you looking at the shaded area, or are you looking at the area behind that?
I'm looking at the area behind it. It's sort of an irregular area. It's not a rectangle. It's a square on three sides, but then there's the angle and the radius of the curve that are incorporated in there. So it's an average I'm taking of the dimensions of the lot. The dimensions of the shaded area where the house would be proposed
Yes, sir.
to be located under the R30 district results in about a 2,400 square foot footprint. So I don't understand the contention that a house could not be built on the property.
That's, I don't know what, can I take a look at with the survey that y'all are looking at? Can one of you provide me a copy of that? Okay. Okay. So yes, in terms of the square footage, absolutely. I don't deny that. But if you look at the configuration of that, again, it's more narrow. It's more again, you've got an irregularity there, and when you look at what could actually fall within that area, I have difficulty thinking that anything that could be reasonably constructed would fit in there. Now, of course, that if you look at the lines, of course, you're looking at the exterior of the house itself. So if you consider the living space within that house, of course, it's going to be much smaller than that.
Well, it's not too much different from the area that's shaded where the house would be proposed to be located if we got the variance approved. So what's the difference?
I would argue that the difference is, one thing, it is more, again, it's more narrow. I mean, if you say you're measuring it at 28 feet, I don't have that measurement on here.
Okay.
But
I don't want to beat a dead horse, but I think the statement that a house could not be built on the property is not germane to this application.
well,
Would you agree?
I don't know the answer to that because these lines are not marked, so I don't know the dimensions of them. It appears to me to be very small. I will say that.
Are there
And
public...
I don't know, and I would add that I don't know that a house If you look at the, give me just one moment, please. Okay, I apologize. Just wanted to look at one thing. I have nothing further to add in that regard.
Are there public utilities available to serve the property?
I believe that there are. The surrounding properties are being served by utilities, so it would lead me to believe that they're available to this property.
Bruce, do you know if there's public utilities there?
There is not public water and sewer, but there would be obviously a power, cable, and other public utilities. I mean, I guess the question references what, when you speak of public utilities, which utilities are you speaking of?
Water and sewer.
To my knowledge, they're not available.
So there'd have to be a private well and a septic system.
Am I correct in understanding, Bruce, that this lot is already non-conforming?
It is non-conforming relative to size.
Right.
Pre-existing non-conforming lot.
Pre-existing non-conforming lot, zoning was not placed in that area until the ETJ was extended, which was after the lot was created in 1981.
Thank you.
There are true driveway pipes in the swale across the frontage of that property. Do you know if both of those driveway pipes are within the property lines?
I don't know the answer to that, no, sir. Yeah.
Are you tapped?
I'll shut up for a while.
Oh, if you have more, keep going. Miles, Kevin, anything you want to chime in on?
I'd like to hear him go through the rest of them on the application before request for variance.
Okay.
If you'd like for me to do that, I'll be glad
I'd
to.
like you to do that. Just
Sure. Starting with the first, so unnecessary hardship would result from the strict application of the ordinance. Again, what we're looking at, if in the with R210 zoning, even conceding that that a house could be built in that location, what that means, of course, is that a house can only be built in that location. So to me, that seems to be an unnecessary hardship. It really gives the property owner no leeway whatsoever in being able to situate the home to his or her desired location within that property. I'll stop right there if you would like for me to discuss, if you all want to discuss that further, or if you want me to move on to point 2, I'll do whatever you'd like for me to.
Does anyone want to have that expanded or discuss further?
Not for me.
Keep on going.
Number 2, the conditions peculiar to the property. We've really already discussed this. Again, it's a lot that is much smaller in size than the surrounding properties. The condition's not common to the neighborhood. So again, I would say that the size of the lot speaks for itself as to conditions that are peculiar to this property, because size, of course, is indicated as an example of that. And I'll stop there for any discussion. The third, the hardship did not result from actions taken by the applicant or property owner. Again, as I mentioned at the outset, and I've got copies of these deeds if you'd like for me to provide them to you now or at some future time, but I'm a real estate attorney. I did the title search on this property, and the property was unchanged in size or in configuration as far back as 1981. So we're looking at 36 years ago, 36 years that it's been in this configuration and size. Again, I'll stop there if there's any discussion. And then finally, regarding the spirit, purpose, and intent of the ordinance, again, I would just say that it's substantial justice. Again, I think that it makes the property much more desirable for a residential property dwelling. And again, there's a property right across the street from it that's residential of a similar size, and again on down the street. So this property seems to me to be more consistent with those two other properties, which again have existing homes on them and are being used for residential purposes. It's hard for me to, I just don't know that under the present zoning, this property would continue to be desirable as a residential property. Again, as I mentioned in my request, the property would primarily have value to adjoining property owners who are seeking to increase the size of their existing properties.
How do you know that?
Well, it just seems to me that if I go out and try to sell someone a lot and I say, okay, now here's where you're going to put the house, and they say, well, why is that? And I say, well, that's because that's the only place you can put the house. Again, I think that's going to limit the audience.
And what does that have to do with this variance request?
I just added as a point of, is it substantial justice? I mean, arguably, I think you could put it into that category.
We might be drifting away from competent evidence in this discussion. Let's refocus on the hardship issues. Any other comments or questions on either 1, 2, 3, or 4?
No, I'm just trying to figure out, same thing as the previous one. Number 1, hardship. The hardship is, how is the hardship defined? How is the hardship defined? The hardship, you're defining the hardship as the placement of the house. Where it would be placed is unusual because of the zoning designation. Yeah.
I think unusual and also constraining, I would add.
Constraining. Yep. Okay. I just wanted to.
Julia, how you doing?
I'm fine.
Okay, Miles?
I'm fine.
Leo?
Fine.
We know that. I would think also about the first item in hardship, and it strikes me that, and I won't refer to it as Leo's argument, but Leo's presentation, that if you were looking for consent that a house could be built there in a different location, there seems to be some agreement on that. I don't necessarily think that because that can be done, it should be mandated that way, and that this would be a denial. That's the only place that you can put the house. A single-family home is a single-family home if it's architecturally appropriate, and the village determines that through the building code and the standards that they apply. So that would be my opinion on number 1. We have a choice, as we did the last time. We can leave the hearing open in case we want to talk to Mr. Adams or Ms. McAllister again, or we can have a motion to close the public hearing and re-enter our regular scheduled meeting and have any further discussion that might be required.
Motion to close the public hearing unless someone has public comment.
Oh, good. Thank you for picking that up. Looks like the answer is no. That's a motion from Kevin to close the public hearing, re-enter our regular meeting. Second, please.
Second?
Julia, all in favor?
Aye.
Aye.
Unanimous. Our choices now are, we could postpone this and talk about it at the next meeting. We could talk about it some more here. We could do as we did in the last case and make a motion, draw a second, have a little bit more discussion, if any, and then go to vote.
I'm going to make an attempt at making a motion.
Okay?
Make a motion not to accept it as presented, but accept it as adjusted, item 1 adjusted by the attorney in positioning the hardship. In other words, the application, the definition, the way he further defined the hardship, because I think Leo had some good points there. But as the hardship was redefined, so really accepting the motion, accepting it as written. Make a motion to accept the variance as written.
Your motion is to approve
Yes.
the application, and you're notating the amended definition.
The amended definition of item 1 hardship. It's important for me to do that because without that, I wouldn't be making the motion.
Does anyone want Kevin to discuss that further so that you're understanding of that?
Would you accept, well, forget about it. They're going to have to comply with all of the requirements of the R30 zone.
That's beyond, that's in the planning and zoning board, the planning department's hands.
Can I have a second to the motion?
I second it.
Thank you, Miles. Actually, any further discussion? And we'll go roll call again. Start with you, Miles.
Yes.
Julia?
Yes.
Leo?
No?
Kevin?
Yes.
I'm 4 and 4 again. 4 and 4. Thank you very much. You will get a written decision within 30 days.
Okay. Thank you all very much.
We have a couple other items, folks, small potatoes, but relative to the Board of Adjustment agenda. One, general business. We do need distribution. Gwendy's gone. We need distribution on the policy procedures that we approved the last time.
We may have to get that to you at another time, Fred.
We need an electronic copy.
We can do that.
Yeah,
Yes,
that's
sir.
all we need.
All righty.
Because we approved it with a couple of subtle changes. Our next meeting is September 7th, and the question is, does anyone have any other business they'd like to conduct?
None.
There's one, welcome Julia.
Yeah.
Baptism in fire.
Yeah, and I would say the best decisions are ones that are contested, and thank you, Leo. And Julia, thanks for diving right in. It's a pleasure having you at the table. Thank you. Motion to adjourn, please.
Make a motion to adjourn.
Second?
All in favor?
Aye.
Aye.
History.